I started mostly after the housing court started.
Okay.
Most of my practice before the New York Housing Court was in New Jersey, because I started in New Jersey, then came to New York.
Okay.
But this is about the housing court, not me.
That's correct.
So
So you weren't
I
practicing.
practiced.
You didn't practice in the house in civil court before they created a special housing court.
Not really. I mean,
Okay.
maybe for a heartbeat.
All right. So what was
But
your experience?
actually no, because the housing court really started in '73.
Correct.
The act was 1972. And when I started practicing regularly in New York, there already was a housing court, but it was very different then.
How was it different?
We had a part with civil court judges. It was called, in Manhattan, Part 49. It wasn't even called Part 18 yet. In Brooklyn, I believe it was 35. I think the Bronx was 17. You can correct me if I'm wrong
Correct.
about that. Manhattan was where I practiced. I was a legal services lawyer, then a private lawyer. You made all of your pretrial motions in Part 18. Since I was usually defense counsel, CPLR 3211 was my friend. I used it a lot,
I think you're still good friends.
maybe. But certainly as defense counsel.
But now, in the old Part 49, say, that was always a civil court judge that sat in that part.
Always.
Now, if your motion to dismiss was not granted in Part 49,
There were a lot of other things to do.
okay. At what
One could
point-
make a motion for summary judgment if appropriate. It's bad to make a summary judgment motion that's a loser,
Mhm.
because if you do, the court can always grant the other side summary judgment, even if they didn't move. Then ready for trial.
But
And you
did
try the
cases get
case.
sent out of Part 49
Yes.
for anything but trial?
They were supposed to be sent out for only trial. Certain civil court judges would really send the motions out, saying things like motion granted to the extent of the motion being referred to the housing part. When I first became a housing judge, as a housing judge sitting in one of the parts with letters as opposed to a number,
Right.
a trial part, we'd get a lot of motions that were referred from a Part 18 civil court judge who didn't really want to do the motion, whereas other civil court judges were delighted to do the motions. It depends. People aren't the same. As a practitioner, as defense counsel, of course, it was great for me to keep a case in Part 49 because they could never evict my client if they could never get to the merits of the case. But I don't have that attitude towards the merits of a case now. I'm a judge. In fact, I want to get to the merits of a case. I have it's a different job.
Very different.
And I found myself wanting to get to the merits of the case and not dealing with stuff that's just going to cause another case to be brought.
Okay. Do you think that the formation of a specialized housing court benefited the parties as opposed to
Yes.
the procedure? Okay.
Very much.
We've had a lot of discussion at our committee level concerning that most people felt that the housing court was formulated to maintain the housing stock, where other factions believe that it was solely to be collecting rents for landlords.
Right. That's how the parties felt.
Right.
It has both purposes.
Do you think that does the court function well enough this way?
I think so.
Okay.
It does both.
Right.
Yes, it collects rent for landlords, but it also furthers the maintenance of the housing stock. I just came out of a year and a half in the HP part in Manhattan.
That was going to be my next question.
I loved it.
How effective is the HP part?
Very. I took it very seriously. The lawyers from Housing Preservation and Development who were in the Manhattan HP part, I can't speak for the other boroughs in terms of the HP part. I don't remember ever really having the HP part except for covering for other judges in the outer boroughs. But I had the HP part in Manhattan twice, once in the mid-'90s for about 2.5 years, and the last year and a half. The landlord's lawyers took it very seriously because they had to, because the HPD counsel in the HP part of Manhattan were very, very effective, each and every one of them, or maybe with one exception, or maybe two, no, really only one exception. And the one exception wasn't so awful, he was okay too, but most of them were very skillful, really knew the housing law, and were quite aggressive. And the reason that that's an effective part is the owner knows that if he doesn't do the repairs, he will get fined. And then they find out that they're not only just agreeing to complete the repairs, which they haven't completed, but they're negotiating, well, how much fine are they going to have to pay? How many $1,000, how many whatever, how many hundred, how many thousand, how many tens of thousands, depending how bad it is. And you find when cases come back, unlike non-payment cases where sometimes the tenant says, maybe correctly, maybe incorrectly, no, didn't do any of the repairs, because the landlord's also asking them for rent, so they have a stronger motivation to say the landlord didn't fix anything. When the tenant brings it back in an HP case because the landlord didn't do the repairs, very often you find there were 4 repairs, they did 2, they didn't do the other 2. Or there were 10 repairs, they've done 6 or 7. And you find they actually do get done. And in order of the court, where it's backed up by an automatic fine if the landlord doesn't do the repairs, is actually a very, very powerful tool to get the housing stock maintained. Which is why, I'm sorry, I'm giving you a very long answer.
I'm so surprised.
When they first formed the housing court, part of the concept was to join the enforcement parts, which were treated as, frankly, very unimportant parts of the criminal court, with the housing parts, where the same court where landlords sued for rent or possession also enforced housing conditions, so the court actually had the power to require the landlord to do something, as opposed to just like paying a small fine like a traffic ticket. If it just becomes a cost of doing business, it's not a very great way to enforce the housing stock, to enforce housing maintenance. Whereas if somebody's going to really be ordered to do something and it's going to cost them serious money and maybe a possible contempt motion, they're going to take it a lot more seriously.
There have been a lot of budget cuts, over the years, and do you find that HPD has been less aggressive in trying to bring actions against landlords that are not maintaining their housing?
Well, I didn't find that the year and a half I just was in the HP part.
Did you
comparing
have
that to the
comprehensive
mid-90s.
actions and 7A
Both.
proceedings? Or
Some 7A proceedings, more comprehensive actions.
Okay.
I found the comprehensive actions much more effective because you're not depending on a third person coming in.
Right.
We just have HPD enforcing the law. And I didn't find them less aggressive the last year and a half than I did in the mid-90s when I also sat in the HP part of Manhattan.
One of the practitioners that we had interviewed had indicated that he had felt that it would even be as far as an improvement or some change to make to the court, to send any case involving repairs, a non-payment proceeding, to the HP part, as opposed to having it run separate and apart from HP actions.
Well, then you'd have to have 3 HP parts, because there are so many non-payment proceedings where repairs are the issue. The HP part would become inundated, and if you inundate a part with too many cases, it will become ineffective. If a judge only has 5 minutes a case, it's very hard to give it the attention it needs. Unfortunately, that happens too much in all the boroughs, in all of our courts with the non-payment proceedings particularly. We all wish we had more time, I think, on every case.
How many years have you been a housing court judge?
Almost 25.
Okay, so you were certainly sitting when the initiative was implemented.
Yes, I was.
Okay, did it have any impact on the practice in housing court?
Yes. I think having separate trial and motion parts is a good idea. Having resolution parts is a good idea. Cases that could settle and can be settled won't take a lot of time away from trials of cases that cannot settle. So the trial judges really have time to try those holdover proceedings, non-primary residence proceedings, owner use proceedings where they just don't want to settle and have reason not to settle, as opposed to cases where somebody needs time to get the money, and you can settle those usually in the resolution part. The separation of the functions is good, and there's another good part about that. When I'm in trial part, I conference anything. I rarely do so much conference on a case that I feel I can't then try it because I know too much, as it were. But if a resolution judge spends a lot of time trying to settle a case and can't, and maybe gets frustrated with either the landlord or the tenant or both, she or he doesn't have to then try the case where the person who they just thought was being unreasonable is going to try to convince that judge that she or he is credible. So I think that separation is good. I think it's also more efficient because there are parts that are set aside just to try cases, theoretically, just to try cases that can't be settled. Although when I was in a trial part, I'd settle loads of cases. But the fact is that you have the time to try the cases, and the cases that can't be settled and the motions, all are done by the resolution part. And people also learn in the resolution part before they go to trial. When I say people, I mean all the pro se litigants. I think 90% of the litigants, at least citywide, I don't know about Manhattan, are unrepresented. And 90% of the tenants who are litigants are unrepresented. 90% of the landlords who are litigants are represented. And the unrepresented tenants in the resolution part, before they have to go to trial, get some idea of what's going on. They talk to the judge, they talk to the court attorneys. The judge asks them what their defenses are. The judge asks them about the condition of the apartment, that sort of thing. And they learn a little bit about, can I do this? And they see the judge. I always make a practice of looking up the building on the HPD website, the HP website. See, what are the violations? Let's look. There are 120 violations in 10 apartments. Counselor, how does your client fit 120 violations into 10 apartments? There's some little joke like that. But, then somebody gets an idea, gee, that's actually important, isn't it? Things like that. So actually it really does help to enforce housing conditions in the sense that the court's obviously paying attention to it. It's not just pay a fine. An important thing that they were arguing about when they first formulated the housing court is the owners were trying very hard to make repair orders and fines and that sort of thing in rem only. And the people who wanted the act passed were very, very, I believe, insistent on wanting to be in rem and in personam, so you couldn't just form a shell corporation, and then disappear. So proper parties in an HP proceeding aren't just the owner corporation, but the managing agent, the principal of the corporation, the party responsible for the building individually. So they know that they can really be held responsible and they can't just hide behind a corporate shell, which is a very important thing that happens here. The HP part especially, but also in the regular landlord-tenant part.
What changes did you observe during the past 30 years that you've been on the bench?
25, please.
Okay, 25. I'm thinking positive.
Thank you. Well, the increase in the number of judges has made things much better. I think, I can't swear to the number of judges we had in 88. I think we only had, about 30 in 88 or 35 in 88? We had either 30 or 35 judges in 88 when I started. Now we have 50 judges. That means that each, there are more judges to pay attention to the cases, so each judge has more time for each case. That was the most positive.
Now, when you
The most positive improvement was the increase in the number of judges, hence the increase in the amount of time you can spend with each case.
When you first were appointed to the bench, did you have a court attorney assigned to you?
Yes.
You did. And you had a clerk in the part?
Yes.
As well as a court officer?
Yes. And the courtroom I was in, it was in the Bronx. It was in the basement of 161 Grand Concourse. It was so small that this little room we're in now is larger. And I mean it, larger than my first courtroom. People, including yourself, Marion, would walk into the front of my courtroom, the outside door. May I approach the bench, and I'd always look at you and smile and say, "You're already there, counselor. You can't get any closer." It was literally that small. We had these little miniature benches with one table pushed right up against the bench with two chairs on the front and one chair each on the side. And you might have a whole bunch of cases in the courtroom. You could only really fit the parties for maybe 2 cases at once. The case in front of you and the next case waiting on the one bench in the back being much closer to the bench than the distance from the back of the well to where the benches are now, at least in Manhattan. And Brooklyn still has terrible facilities. Physically, everybody knows that. It's not a matter of size so much as condition and structure of the building. But,
Now, what do you think worked or didn't work with the changes that have been made in housing court? Or what changes would you like to see made?
Well, I think the initiative, as you called it, actually helped a lot for the reasons we just discussed. Another change I'd like to see made, I'm a housing judge. It's not going, since I'm 70, it's not going to affect me much, but I really think housing judges should have 10-year terms. Having to reapply for one's own job every 5 years on 2 different, very long, detailed forms isn't fun. And the advisory committee doesn't want the judiciary committee questionnaire, you know, the Bar Association committee of on the judiciary has its own form. The advisory council has its own form. They ask for almost the same information, but they're different, so you have to fill them out separately, a few extra questions on each. But that's not the worst thing. The idea is, in only 5 years, it seems you just applied for your job and just got it, and now you're applying again. It would be good to have 10-year terms. I think it would create more judicial independence, especially since the advisory council is composed, among others, of lawyers who appear in front of you. And lawyers should, if they're on the advisory council and you're up for reappointment, and they do, say, Judge, I'm in the advisory council. I know you're up for reappointment in a couple of months. Do you have anything do you want to recuse? Do you want to do something or not? But whether you do or not, those lawyers are there. They're fine. I like them all. I hope they like me. But the fact is that having that every 10 years isn't so bad. Having it every 5 years puts a lot of, I think, pressure on the judges. I try to ignore the pressure. I think I managed to succeed in ignoring the pressure, especially after all these years. And I've been reappointed a lot of times. But it is not fun. It's not fun to have to reapply for your own job again and again. So I think the main thing that I'd like to see, and it won't even affect me, because I am, frankly, reapplying for another 5-year term, but really only for 5 years, because I'll be 75 at the end of the next term. But for all of my colleagues who are younger, young folks such as yourself, Marion, should be able to have 10-year terms so you don't have to keep reapplying every 5 years.
Any other changes suggested for the court itself?
Not better facilities for Brooklyn, excuse me. A real courthouse for Brooklyn with back entrances to the courtrooms and enough room for all the litigants and elevators that work. I'll put in a word for Brooklyn, although I sit in Manhattan.
Absolutely.
They need a decent courthouse.
A long time coming.
And the Bronx needs a bigger courthouse. They have, I know from you, the trial, the trial part in the hallway in front of the elevator. And the elevator opens in the courtroom and people are walking by. They need more room. I don't know if they can build up on top of it or what.
I doubt it.
I doubt it too, from what I've heard. But I'm not, the Manhattan facilities I think are great. I love this building. We're sitting in 111 Center Street now, obviously. I think this is a great building for a courthouse. Queens Courthouse is absolutely beautiful. Just beautiful. Probably the best of all of them physically. But Brooklyn courthouse really needs to be replaced with a real courthouse, and the Bronx needs more room.
Yeah. Is there anything else you'd like to add before we wrap up?
Well, yes. People don't understand how difficult a job being a housing court judge is. Being a housing court judge, I think, is more difficult than being a civil or even a Supreme Court judge. You're dealing with people's homes, their rights to keep their homes, and that's one of the most important things in a person's life. And another thing that people don't understand about housing law is it's not simple. It's complicated. And Wall Street lawyers who go to federal court all the time and Supreme Court on plenary actions don't really understand that the law we deal with is more complicated than the law they deal with. It's more complicated than federal law. It's more complicated than criminal law. You have the interplay of the rent stabilization law and the rent stabilization code and Section 8 and the rent control law, all kinds of different statutes, the multiple dwelling law, the interplay of the different statutes, real property actions and proceedings law and the CPLR, and where they differ and where they're the same. Where, I mean, two of my favorite examples, where the rent stabilization code was held to be wrong. In Roberts against Tishman Speyer, where the DHCR had passed a rent stabilization code allowing landlords of apartments receiving J51, and who are also rent stabilized, getting high rent destabilization, which absolutely violated the 1993 statute, and the arguments about whether the Court of Appeals case, Roberts against Tishman Speyer, was retroactive, and it is, and we have held that it is. Another regulation that was wrong was talked about in Sampson Management against Hubert, Appellate Division, Second Department, where the rent stabilization code was allowed landlords to deem leases, even though 232C of the real property law says you can't hold a tenant for a term of any more than 1 month up to for another whole term, for another whole year. So that regulation violated 232C of the real property law. And the rent stabilization law had its own section saying any section of this code which violates any other state law is unenforceable. And they held that, and that surprised some people. It didn't surprise others. But it's a fascinating area of the law, and it's not, quote, simple, unquote. And I think that's something that people need to understand about the housing court. We don't deal with easy, simple legal issues. We deal with interesting, complicated legal issues, and that's what makes it a very challenging job.